Order. Tommy Shepherd to move the motion.
Thank you, Mr. Gates, and a pleasure, I think, for the first time to serve under your chairship. I'm delighted that I've had the opportunity to present this debate today, and I rise to move the motion that this House has considered human rights in the UK. Not for the first time, of course. We have, over the last few years, particularly since we began our Brexit journey, discussed the matter of human rights in the United Kingdom and what consequences there might be for that were this country to leave the European Union. And a number of colleagues, most notably my honourable and learned colleague, member for Edinburgh South West, but others as well, have sought assurances from ministers that human rights protection in the United Kingdom would not be in any way diminished as a result of this process. And by and large, those assurances have been given. So why, therefore, is it appropriate to discuss this again today? Well, I think for three reasons. The first is that we've moved on in the Brexit process, and we now have a political declaration, or I should say a draft political declaration, which seeks to define the relationship that this country would want to have with the other 27 members of the European Union after, if indeed it does, leaves the European Union. And a number of us have noticed a slight change of language in that declaration when it comes to human rights. No longer is there a clear-cut commitment to support and embody into domestic legislation the European Convention on Human Rights, but in fact there is talk of respect for the framework which the ECHR provides. And whereas, of course, the other signatories to the political declaration, the other 27, are quite clear in their commitment to the ECHR. So that suggests that there may be the possibility of some divergence between the United Kingdom and the other member states of the European Union in terms of their implementation of the ECHR. Also, of course, we have a situation where a government is led by someone who could hardly be described as being absolute in their commitment to the current human rights legislative framework in this country. When the current Prime Minister was Home Secretary, I would argue that she sought to undermine the Human Rights Act by suggesting that it was in some way soft on terrorists. Also, of course, it's worth noting that when she stood to be leader of the Conservative Party, she ruled out the possibility of repeal of the HRA, not because of any matter of principle, but because there was not, in her words, a majority for it in Parliament. So one wonders what her position might be were the majority in Parliament to change. And finally, of course, we have a situation where the Conservative Party, the ruling party of government, was elected on a manifesto which pledged that there would be no repeal of the HRA whilst the Brexit process was underway. Now, who am I to guess whether the Brexit process is nearing its end game or not, but it certainly looks likely that in 2019 it will get to its final stages, and we may or may not leave the European Union. So the question, therefore, comes about: what would the governing party's policy be on repeal of the HRA once the Brexit process has been completed, or at least got to a position of being implemented? So for all of these reasons, the central purpose of today's debate is to seek an assurance from the Minister and from the government that there will be no attempt to repeal, to undermine, to weaken or amend the provisions of the Human Rights Act of 1998. Now, I feel often when we discuss these matters of human rights that our discussions can get somewhat abstract and they can go over the heads of the ordinary men and women in the street. So I think it is important that we take this opportunity to state clearly why it is that human rights are so central to everything that we believe in, because in essence, human rights are an expression of what we mean by civilization. They define how individuals should react with one another. They confer respect and dignity upon the individual. And crucially, as well as setting standards for the type of behaviour we would expect from others, they set obligations on the type of behaviour we ought to give to others. So I would argue that the existence of human rights is absolutely central to our well-being as a healthy and dynamic society. People have suggested, and of course it's true, that very, very few people ever think about their human rights, and they certainly don't need or feel the need to go to court in order to have them upheld. In fact, I doubt if other than a very tiny percentage of the population even know of anyone who has went to court on a human rights matter. But that in itself suggests how powerful and how useful the legislative framework actually is, because the central point of human rights legislation is not to allow people to seek redress if their rights are infringed. It is to protect them in the first place from people doing bad things to them. And the fact that there is so little court activity in this field, I think, is a vindication itself that the system is working. But of course, there are cases where the system doesn't work and where people feel the need to go and have their rights upheld. And I think it's interesting to refer to a few of these so that we understand and the public can understand just how central these matters actually are. Celia Peachey didn't think the Human Rights Act related to her at all. Her mother was killed at the hands of a violent partner, and she tried for years to get the police to do something about it, but couldn't persuade them to intervene. After her mother died, she was able to use the Human Rights Act in order to secure an inquest which returned a verdict of unlawful killing and criticised the police for the action that they had refused to take despite her making representations to them. The Driscolls were an elderly couple who depended on each other for care and support just to go about their daily lives. And when Mr. Driscoll was rehoused in a residential care home, his wife was not allowed to go and live with him. They used the Human Rights Act under the article of the right to a family life to argue that they should be rehoused together, and they won. And they were rehoused as a couple. In fact, not only was that of a benefit to them, but they set a precedent where it is now normal in these cases of considering residential care for the elderly to consider rehousing couples together. People will know of the case of Gary McKinnon, a young man with Asperger's who allegedly hacked into a NASA computer database and was wanted by the United States of America. They tried to extradite him to face charges which would have led to 60 years imprisonment had he been found guilty. He tried to resist that extradition, and in fact, to her credit, it was the then Home Secretary who, in 2012, supported and said she was not going to allow him to be extradited because, under the Human Rights Act, his rights would be breached were he extradited to stand trial in the US. And of course, the celebrated case of the black cab rapist, Stephen Warboys. There were two of his early victims in 2003 and 2007 who went to the police to complain what had happened to them, and their actions, their complaints were not investigated at that time. They used the Human Rights Act after the case came to prominence in order to get an inquiry into how the police had dealt with their complaints, and it was found that it had not done so correctly, and the police were reprimanded, and the victims received compensation as a result of their ability to use the Human Rights Act. And of course, many people will know of the continuing campaign by the families of those who died in the Hillsborough disaster to seek justice for their loved ones, and they have repeatedly used the Human Rights Act over the last 20 years in order to move their cases forward. And the final example I would give is the case of people trying to get redress against public authorities, particularly the case of health authorities, and in this instance, Mid Staffordshire Hospital. I don't want to go into any detail about the sad state of affairs in that institution, but suffice it to say that 119 families have now used the Human Rights Act in order to seek redress about the treatment they have received from Mid Staffordshire Hospital. So all of these are important things. They quite literally often make the difference between life and death, and they are central to the quality of life that our citizens have. So let's turn now to the context of Brexit and what the implications might be for some of these protections. In one sense, I mean, we've talked about the European Convention on Human Rights and the wording that's used in the political declaration. In one sense, you have to wonder why this is even an issue at all, because, of course, the ECHR is not the creature of the European Union. It is the creature of the Council of Europe, an organisation to which this country subscribes and which involves 47 European countries 40% of whom are not members of the European Union. So one wonders why it's even being talked about in the context of Brexit at all. And there's been a suggestion that perhaps the commitment to the ECHR, if it's taken seriously, is in some way an encumbrance, a hindrance on the process of government and prevents the government acting freely. And I know that some on the rather more extreme wings of the Brexit movement would suggest that this is a foreign intervention on the ability of an independent United Kingdom to do whatever it wants to do. Well, it's a good hindrance because it obliges us to conform to international norms of civilization which most people throughout the world actually subscribe to. And when you look at the United Kingdom's record in terms of complaints under the ECHR and judgments at the European Court of Human Rights, actually, it's a very good one. The United Kingdom is right down the bottom of the list of countries that have cases taken against them. So this, in many ways, our association with the European Court of Human Rights and with the process and the upholding of the Convention of Human Rights shouldn't be seen as some sort of hindrance. It should be a vindication, actually, of the fact that this country is actually quite good at holding people's human rights when it comes to how things are governed. There's also a concern, of course, that one of the reasons behind the debate on revisiting human rights legislation might be, as some people would see it, to free up the United Kingdom in terms of international trading arrangements in a post-Brexit scenario, in order to perhaps, I don't know, I mean, the International Trade Secretary is not doing that well in terms of signing up these agreements, but as time progresses, I'm sure there will be more come on our agenda. It is important, I think, now, at the very beginning, before we get into this, that we say we're not prepared to trade standards of human rights in third-party countries that we want a trade agreement with in order to secure trade with that country. We must be seen, surely, as a country that upholds human rights standards, not just in this country, but uses our power and our authority to be able to make sure they are upheld internationally as well. So for that reason, I would also like to see the Minister suggest not just that there's no intention to diminish the current protection we have, but to explore in a post-Brexit scenario, if indeed that comes about, how the human rights are going to be protected, not just in this country, but throughout the world. And of course, one of the problems here is that we're talking about something that to some extent has already happened. Last summer, when discussing the European Withdrawal Act, the government was very keen to make sure that the EU Charter on Fundamental Rights was not included in the British legislation, despite the opposition from my party and from many others. And the government's case, of course, was that, well, actually, all of these individual rights are replicated elsewhere anyway, so it's unnecessary, it's duplication. Well, notwithstanding the fact that that's not quite true, there are some rights in the EU Charter which are not in the ECHR, it misses the main point. The purpose of the EU Charter on Fundamental Rights is not just to define the rights that people have, it was to create obligations on member states of the European Union on how they would be upheld, and in particular to assert the primacy of rights over other legislation. And the QC Jason Koppel, in his advice that he provided for the Equality and Human Rights Commission, put this very clearly when he cites the case of cleaners in the Sudanese embassy who had tried to go to court in order to uphold their employment rights, who were told that they didn't apply because of the 1978 Immunity Act, where foreign embassies were exempt. They used the Charter to go to court and argue and to win their case that, in fact, their employment and human rights at work were more important than the Immunity Act, and that latter act should be set aside in order to ensure their rights. Now, the tragedy is that if we go ahead and exit on the 29th of March at 11 p.m., the Charter's gone. It no longer applies. So those cleaners would not be able to take that case that they did in 2017 in the future. And that is a diminution of the rights that people have. Can I just, in the final part of what I want to say, I believe that it is vitally important that we are not complacent about this, that we look at ways in which we can strengthen and develop the application of human rights in our country. And to that end, I want to say something about the situation in Scotland, because I believe developments are happening there which can provide some leadership to the rest of the United Kingdom and indeed to the other nations within the United Kingdom. Now, the Human Rights Act itself, of course, is a reserved matter for the whole of the United Kingdom. But the European Convention on Human Rights, which the HRA enshrines, is fundamental to the devolution settlement in Scotland and in Wales, and, of course, to the Good Friday Agreement in Northern Ireland as well. Scottish ministers are required to comply with the ECHR in everything that they do. And for that reason, and also for the simple reason that the upholding of most people's human rights has an awful lot to do with the processes, the day-to-day processes of government. For that reason, the Scottish Government is very keen to look at how human rights can be developed and incorporated into Scots law. And there is a recent report that's just published before Christmas from the Scottish Government's Advisory Committee on Human Rights Leadership, chaired by Professor Alan Miller, which I would recommend to colleagues to have a look at. It is a very good report, and it sets an agenda over the next 5 years as to how this matter can be taken forward. It sets 3 central principles in the context of Brexit. The first is, as we've already discussed, that there should be no regression in human rights protection as a result of Brexit. But the second, which we often don't talk about, is that we need to keep pace with any improvements in human rights protection in the rest of the European Union. So it's a matter also of having policies in place to ensure that this country does not lag behind the EU 27 or indeed the Council of Europe 46 if things are happening in that basis. So we need to keep pace. And the third theme that it talks about is how really to make it real, how to integrate human rights protection into the very processes of government itself. Now, the report splits human rights into different categories. The one that people are most familiar with, of course, is civil and political rights. You know, the right to life, the right to vote, the right to free expression. And these, of course, these are central to the ECHR and to the Human Rights Act itself. But, of course, there's a whole other dimension of human rights that we talk about, social and economic rights, the right to health, the right to shelter, the right to work. People talk about these as well as being rights that are essential to defining the nature of the society in which we live. And this report is very instructive in that it begins to take that debate forward, so that these rights aren't just talked about as abstract principles, as objectives to be attained, but actually government policy is shaped towards their delivery. Now, I'm happy to debate this point. There may be some colleagues here from the libertarian right who can put an alternative point of view, but to my mind, delivering on these social and economic rights has to bring up the question of the regulation of resources in society, because essentially what these rights are about is a fair allocation and sharing of resources between people. Now, that doesn't mean that it's the government's responsibility to provide everybody with the keys to a 3-bedroom house, okay? But it does mean that it ought to be the government's responsibility to ensure that there is a public policy framework for housing, the objective of which is that everyone should be adequately housed. And it should also be the government's responsibility that in cases where regulation or the market fails to achieve that objective, there is a safety net provision in order to provide basic shelter. And in order to test whether government policy is actually delivering on those rights, we need to make sure that the notion of human rights is integrated into government at all levels. So I would finish with this point, really, because I think there's much that can be learned from what is happening in the Scottish debate, and perhaps the Minister will want to comment on it and to suggest whether that debate might be able to happen in the United Kingdom as a whole. But what is central to this is the fact that human rights cannot be seen as an add-on to policy, not as an afterthought. They need to be central to the policy of government at all levels. And that means perhaps in the future it won't be a minister from the Justice Department who's responding to this debate. It would be more fitting to have somebody from the Cabinet Office or the Deputy Prime Minister or the Prime Minister themselves, because it needs to be driven into every aspect of government policy. It shouldn't just be seen as something that exists it's a concern of lawyers of the legal department. It has to be central to how we do the business of government. And I commend this motion to the House.